Good morning. Today's date is January 28th, 2025, and this is the Vermont Parole Board for their monthly board staff meeting. I'm going to kick it over to the chair.
Thank you. Morning, everybody.
Morning.
Morning, Meredith.
Good morning.
Good
So
morning.
our first item on our agenda is to review the agenda. Are there any additions or deletions suggested by anyone to the agenda? Hearing none, I would entertain a motion to approve the agenda as published. So moved.
I'll make a motion to approve the agenda as published.
Thank you.
Second.
Motion has been made and seconded to approve the agenda. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? It is unanimous. Next up is to review and approve our minutes from our staff meeting on August 27th. And as MJ has mentioned in the agenda, the meeting in September was a training session, so there are no minutes from that meeting. Has everyone had a chance to review the minutes from the August 27th meeting?
Yes.
Yeah.
Yes.
Any corrections or changes suggested? Motion to approve the minutes from the August 27th meeting, please.
So moved.
I'll make a motion to approve the August 27th meeting minutes.
Thank you. Second. Motion has been made and seconded to approve the minutes from August 27th, 2024. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? We are 6 in favor and 1 absent at this time. Thank you.
We have
Colby. Good
two.
job.
We have 2 absent, Dean.
2 absents. I'm sorry. I forgot about Sam. Yep. Thank you. First up is our victim services meeting with Meredith, and I'm not sure if Ashley is coming as well, but good morning, Meredith.
Good morning. I don't know if she'll be here or not, but
Okay,
we could start without her.
great.
So, just some things have been coming up for Victim Services Unit. And I just want to talk to you guys a little bit about that and see what things are coming up for you as well with Victim Services.
Sure.
So, you know, we're trying to be a lot more prepared, of course, when it comes to being on time and making sure victims are ready. Sometimes that's hard if there's multiple victims. So
Sure.
my apologies if that happens. Another thing that's come up is continuances. So sometimes when we, there's been at least 2 cases where we've had to continue because somebody wasn't ready or something happened, and
Sure.
we've had to ask the victims to come back multiple times, or it's because the other attorney is asking for a continuance. So that's been a bit of a struggle for us as well with victims. So I just want to put that out there for you. Not that that's always in your control, but
Right.
something for us to be thinking about. Also, I've noticed on some of the hearings I've been sitting on that I didn't feel like things were being represented accurately by the department. So I'm doing some work around that as well to make sure that we are getting everything on the record, or at least making sure you guys know even ahead of time what are our concerns from the Victim Services Unit.
So would these be cases, Meredith, like where a victim may not be present, but you're participating in the hearing representing the victim, and something is presented to the board, but you haven't had a chance to discuss that particular issue?
Or you know, maybe we didn't get a chance. It may be last minute. The victim may call us last minute, and we won't have had a chance to have a private session. So, and the victim will want that on the record. So we may hop in if that's the case. That's going to be rare because hopefully we get in touch with people. Yeah.
And
way ahead of
Meredith, Is this also regarding, say, DR information in an individual's case that may not be stated on the record? I'm just using that as a general example. Or if DOC is not giving all the information on a case, however, for whatever reason, and you've noticed that there should be some information that should be given or something to that effect. Because I think that was one of the cases that came up.
Yes.
So that's why I just wanted
Yes.
to also clarify, it may not just,
Mhm.
I'm thinking this isn't just victim information, correct, Meredith?
Correct. It could be behavior that maybe isn't being presented. So
Okay.
it may not rise to a DR level, but
Mhm.
it may be behavior that I think is important for you all
Yeah.
to know. So
Yeah.
that case in particular was challenging, as we all know.
Yeah. Well,
Um,
hopefully you get a chance to review the information that comes out prior to the hearing. So if there's something that you want to call our attention to, you can have the opportunity to do that.
yes. And, I've heard, people say, sometimes we don't want to put the caseworker in that position.
Mhm.
But my feeling, and it may not be the department's feeling, but is that it's up to us to represent that because, public safety is our jobs. And so I don't love this setup, and I've talked to them about perhaps not having the offender sitting right with the caseworker and maybe having, I don't know if there's a solution. As you know, we have staffing shortages, but I'm
Yeah.
trying to see if maybe there was a way we could, because it is hard for caseworkers to be sitting with the offender right next to them, especially if they're nervous or scared of this person,
Yeah.
which
And
in that
potentially,
case,
yeah. I can recall one case where that was an issue in Newport that comes to mind. And it was obvious to us anyway that was an issue, and I think we might have been alerted to that by one of your folks, if not you. I can't remember who was representing it, but it was very
Yeah.
helpful to know that in advance.
Yeah, absolutely. And also, I've noticed some things I've noticed is that the caseworker may be standing in the back
Mm-hmm.
and the person may be sitting with their attorney. And so it doesn't feel to me like the department's really being represented in those cases very well. So I've been working around that too. Like, how do we get the caseworker to be,
Are you talking about violations or parole
Yeah.
hearings? Because the caseworker doesn't really have a role in the violations, so that's why they stand in the back. So
I'm talking actual hearings too.
like parole I can understand parole hearings, but I just want, for violations, I think they step out to allow, because they don't have a role in a violation hearing.
Yeah, yeah, I understand that, but no, it's more for the hearings.
Yeah.
So, just so you know, we're seeing some things where, and it's our job to advocate for the victim. So,
Of course.
even in within our department. So, I just want to make you aware of some things I'm noticing, that I'm trying
Absolutely.
to fix. So, I didn't know if you guys had any feedback for me.
Thoughts from anyone? Care to mention anything?
No.
I think the only feedback that I had, Meredith, that we've talked about is that the more advance notice that we have prior to a hearing of participation, the better. So that way we can plan accordingly. And we've talked about that.
Yeah.
Yes, and I've mentioned that to my folks several times. So hopefully that problem doesn't persist. But from time to time, I will jump on just to, make sure that I understand what's going on in the hearing. So if I need to do that, please let me know too.
The important things, obviously, whenever we have a parole eligibility hearing, it's, if there is victim information, it's great to have that in advance. And I think for the most part, you guys do a great job of getting us in touch with them, and we get a chance to meet them first. At violation hearings, I know it's tricky, particularly when there is confrontation of the witnesses, and the witnesses are often victims. And it's one of those issues that's tricky, but we try to navigate through that without having any adverse impact, or try to limit it as best we can.
Yes,
But
yes.
preparation for the victims from you folks before these hearings is helpful, because we cannot participate in interviewing them or talking with them prior to a violation hearing.
Okay, that's good.
I
too.
also think just a re-up with your staff might be helpful too around violation hearings and the role of a victim, because that does come up time to time before hearings about victims who want to speak at violation hearings, and the rules around violation hearings is different, and it's not necessarily the same as coming in and giving the input as they would in a parole hearing. So I think there's some confusion sometimes around that as well.
Okay, so victims are not allowed to speak during violation hearings unless they are called as a witness. Is that accurate?
Well, in the disposition part of the hearing, once the evidence has been considered and determined, and we're in the disposition part of the hearing, if there's impact on a victim that needs to be clarified or addressed, that's an opportunity to present that. Typically, we give the Department of Corrections the opportunity first to weigh in on disposition, and then the offender's counsel for the offender. So it works really well when the victim has communicated with the department's representative that this is an issue for the victim, so they can present it without having there be direct information from the victim necessarily, when that can
Okay.
happen that way.
Okay, great. Perfect. I will talk to them about that. That's great to
Great.
know.
Anything
think
else for us?
No, I think that's it. More to come, maybe.
Good.
But I would love to try to come next time too for
Absolutely.
like 5 minutes. Okay.
Absolutely. No, it's a perfect time for you to get any updates from us or provide us any information that we need to know. Absolutely.
Perfect.
Great.
All
Thank
right,
you, Meredith.
everybody. Have a good day.
Thank you.
Thank you.
Bye.
Okay, public access, participation in hearings. MJ, you want to speak to that? I think things have
Sure.
improved greatly since last month.
Yes, and Lori is here too, if she has anything to add to this. So after a conversation that our counsel Lori Fisher and I had around hearing attendance and our the YouTuber that was posting our hearings with commentary, we have since restricted hearing access to members of the public who are directly involved in a hearing or a resident of the state of Vermont. We feel that the open meeting law is tailored around Vermonters and having them, having access to the transparency of state government and those that are directly impacted. Since then, our YouTuber has only joined, he, once when he wouldn't state where he was from, he did come back at us. Vocally, we removed him from the room. He has not tried to access our hearings again. He did remove all of our hearings from his YouTube site. However, we did not ask him to, because that was prior to this change. And I don't know if they're still accessible in his subscriber page or not, because he does have a subscription only portion of his YouTube page. But that's where we're at. I have not heard from him. He threatened to go to the news outlets. I have not heard anything. So
Yeah.
That's where we're at.
That's good. We talked to MJ about possibly moving over to the WebEx format. Is there anything more on that?
I am still waiting for a quote on WebEx right now.
Okay.
Right now, I think we're doing okay. It's been working fairly well. Going to WebEx, it would be nice to be able to talk to people in the lobby, because right now, what I've instituted is I'm not admitting folks in the middle of a hearing unless I know who they are. from a witness list, or somebody stated at the beginning of a hearing, so-and-so is planning to come. So I'm not admitting them until there's a break in the hearing. That
Yeah.
way I can have them
Right.
announce themselves.
That works well.
So that's kind of what we've been doing. It's been going okay. I've not had any issues.
Anyone else have any thoughts? Tom?
I'm on a criminal justice board here in Rutland for years, and I always say that if they want to, that they can go to they ask about the parole board, and so here's the link, and you can, if you want to observe them. Is that still something that they can do, or, yeah? So I just give them the link and say, you can help you guys if you want to do it. Or,
We just need to know we need to know reasons behind why they're here and what they're doing, what their purpose is, and also where they're from.
And if
all-
they're
And also-
observing, that's
and-
fine. Yeah.
And also we're required by the open meeting law to have a physical location. That is why I have my background on, but that is why I am in the office today. And that's why I'm in the office every hearing day, is because the office is our physical location if somebody cannot attend remotely.
If we say, if they want to observe because they're a resident of Vermont, do they have to prove it somehow? Or can they just say, yes, I'm in Vermont?
I don't
We're not
think I'm,
looking for any proof.
here comes Lori.
It's gonna be hard to do.
No, fair question.
Show me your
but we're-
driver's license.
Because I don't know
Okay.
how, I think anybody could probably just say, yes, I'm in
Vermont.
Sure. I mean, and the point of all that is to, think about litigation defense. And if someone, he's going to have no standing to bring an open meeting law violation complaint anyway, but it puts them on the record to say, yes, I'm a Vermonter. Yes, I have an interest in this case. Yes, whatever it is. We ultimately find out in litigation that they're not, then it ups the ante on the penalty for abusive process. So
Oh,
It's
okay,
a-
so
it's a-
it's there
it's a
if we
set-
need
it's-
to prove it.
yeah,
It's there if
yeah.
we need to.
It's
yeah.
on the record,
Yeah.
whatever they
Yeah.
say.
Okay.
So
Yeah.
they're
That makes
basically self-attesting to something. But yeah, we have no litmus test as to whether it's accurate or not, but we can at least acknowledge that we relied upon the information they provided and found that that was true or not true.
Yeah.
So,
Okay.
yeah.
Good.
And I just wanted to add, you all are in charge of how open meeting law is part one. Part two is your procedure and process. And you have the ability, I would argue under statute, to protect people, both the offender and the victims or the officers or yourselves. So, as far as defending any kind of boxing in of characters like that are going to use it for nefarious, he's not using it for any valid purpose. He's using it for entertainment.
Right.
We can walk right up to the line on that and still not violate state law and be transparent with Vermonters. So it's a balancing act. I think you guys have a little more room to push it if it returns to being out of control. The other piece too, I would just caution you on, without, being open on legal advice, but just be mindful that if you, prisoners' rights have noticed us, and they're telling you that if there's medical information involved with their client, in relation to their presentation, they're going to ask you to go into executive session for just the limited purpose of dealing with the medical information so that it's not on the open record. They're entitled to do that. You're entitled to indulge them in that, but you have to come right back out of executive session when you're done looking at that information. You can't turn it into go in under the guise that you're, and I'm not inferring that you are. I just want to be clear on that. Because prisoners' rights that's their approach to kind of defending this as well, which I wholly support. I just don't want you guys to walk down it's a fine line on that piece. You got to come right back out as soon as the medical information has been presented.
And it's
And
hard
then-
because we did have one of these cases and it started to go down the slope of trying to get out of medical into other stuff. So
Okay.
just, it's easy to keep on going without coming back out of executive
Yeah.
session.
Good
Yeah.
point. Thank you. And that includes mental health issues as well?
Yeah, I would say anything involving mental health, or physical health, physiology, anything to do with, analysis of bodily function, I would caution you to take that seriously. The caveat is, I've also, when I spoke to prisoners' rights about this, is I don't want there to become a mechanism where they try to bootstrap medical information to their defense just for the purpose of going into, which again, not implying that that's any thought process, but I want to get out ahead of it to try to fend off, any potential appeal out of that. So, very limited purpose that's very relevant to the violation or what the matter before you is really the focus. And I believe they understand that too.
And I think that this change that we have made recently has, I think, calmed that front down as well. Because I think it really matters who's in the room a little sometimes too.
Okay.
Well, and it definitely, there's not a lot of case law on it specific to this issue. And that's an interesting thing for me, considering what a digital age that we're in, obviously.
Wouldn't
But
these, excuse me, but wouldn't these issues have to be proven by prisoners' rights that it's a documented medical issue, that it's a clinical issue? I assume what we're trying to do is avoid HIPAA violations, but if some guy's gonna start talking about, well, I got a really bad back because I can't work, that has nothing to do with medical treatment.
Right.
So I think there's a really fine line here that I think prisoners' rights has to document that this is a clinical issue and he's seeing a professional that's covered by HIPAA before we go there.
So Wayne, in the one case that we did have the background prior to granting the executive session. We did get a detailed rundown of the reasoning for the request to go to executive session. And it included more of that detailed medical information, not just the generalities.
Was that in the report, MJ, or was that something that came
It was an
out?
email it was a request that came in later. I can't remember the
okay.
exact case, but it was an email request that came in later.
Okay.
so that would go through the normal protocol,
Mhm.
that, that MJ, that they go through when the request is made. If we want to change what you're going to do, it's up to you whether you guys want to do that and whether you have enough information before you to make the decision to alter your proceeding.
Right.
So whatever that is, Wayne, you're right on point. I mean, they would have to show you. And I would, again, being careful with open public legal advice, I'd be very careful on the analysis on how that attaches to the matter that's before you.
Mhm.
Someone having a bad back is unfortunate, but did that cause them? Is that a mitigating factor for their behavior and something that they did? Is it causally connected? Does it meet your evidentiary standard that applies? So,
Or
yeah,
is it a reason they can't work at this time, which is much different, obviously. Yeah.
right. And again, I would, from an evidentiary standpoint, anybody can tell you anything about anything medical as a fact witness, my back hurts. I can't get out of bed. When it comes to what that means for them in relation to things like workload, what they're allowed to do, I would suggest that medical professionals and that's where expert witnesses come in, and provide you that information. It's really easy for you guys to get pulled down this just discussion and back and forth and, persuasive argument, but to Wayne's point, using medical information as a validation for something or a reason to not do something, you know, does require a higher level of burden. So for what that's worth, I just,
Yeah.
it just, I don't know how much medical that you guys see on the whole. But it just be prepared that that's, I think, going to be part of the approach to fend off the YouTubers. But it sounds like just calling them out and asking them to identify what their role is and how they are interested in the proceeding has
Yeah.
at least initially made them back off. So good job, MJ.
Yes.
A quick
Thank
question,
you.
Lori, what I've seen many times, the Defender Generals, what they will do is somebody has medical issues that they will not be able to be treated well, in their opinion, by the Department of Corrections. So when they're talking about things of that nature, about what they have, is that something that we go to executive session for? Or that just saying thank you for sharing, or
You know, I mean,
that happens a lot?
I think that just narrative about, you know, an individual's overall health issue and how that would impact them. You know, I think it's going to be case by case, and whether you guys feel as though you need to get into the medical records, whether you need more information on that piece. You know, a lot of these folks, you have history with them. The file's pretty clear as to what their history is. A lot of times it'll acknowledge, because I consider that to be mitigating factors most of the time, or aggravating factors to the situation, less about arguing that somehow defends the behavior, if that makes sense. I don't know how you
Yes.
guys think about it, but that's how I
Mhm.
that's how I see medical information in your world, is how it's relevant.
When they start
So-
coming in with physicians as witnesses and medical records, that's different, but just giving us their thoughts on what's going on with their lives, that kind of thing.
Right. And that's why I think, to Wayne's point, and what you did last time with that situation, is make them proffer up why they're asking for it. You know, if either side asks for something different out of queue, then I would certainly make them kind of initially. A lot of times with the judiciary, you have an initial offering of what you're going to argue and why you need it reviewed in camera, or why you know why it can't be put on the public record. And then once that preliminary ruling is made, and then you either file it in camera, or in your case, go to executive session or not. But you have the ability to control that information. That's why it's important that they help you understand the why and how it's relevant to what you're assessing.
How about,
And then we have the same as role when we're releasing these records, if we have a records request to review that information as well.
Yeah, I mean, MJ just got one under a subpoena for a case, and your records include a psychosexual evaluation. Well, you're not allowed to issue that release that without a court order.
Yeah.
So it's super important that, you know, you accepting that information into your record puts an additional burden on your administrative process if things need to go back out. So you know, there are occasions where, like, the Human Services Board may not accept certain information based on relevance, but they don't want to have it in their file. So just be mindful, you guys control that.
so Lori, I understand you're not our attorney, but this is really starting to make me think about a lot of stuff we do and the slippery slope we're going down. So a lot of these defendants, or our eligible people, have signed waivers to their treatment facilities. The department is reporting on their success or failure at those facilities in their reports. That waiver that guy signed is between him and the Department of Corrections, not us. So,
Well, there are times where they do sign waivers indicating that information can be used. We do have one And I am still your attorney. I don't know if you want
Yes,
not
yeah,
that be the
Yes.
case, but I still am
Thank
your
you.
attorney.
I'm not getting
I'm-
rid of you, Lori.
I'm trying not to be so that you don't have to worry about the crossover, but I currently am.
Yeah.
But there are agencies that are pushing back. There's a Supreme Court case that came down recently in the parental termination juvenile world, where the Supreme Court said certain information specific to termination of parental rights, as an example, it may only be released by the Department of Children and Families on a need-to-know basis, on a limited basis. And so often parents that are going through the termination process, you know, they start out as reunification, they'll sign releases and say, you can talk to the department about what I'm doing for treatment, how I'm cleaning myself up or what I'm doing. The next step is what you do with that information and by way of the proceedings. And the Supreme Court said, at least in those, it's a need to know basis. And the Human Services Board, as an example, is not a need to know board that would receive the information. So I do anticipate there'll be some future workings on being released to the department and then an additional release to be released to you for purposes of the situation. So currently they're under their contracts that they sign, whether it's furlough or parole release, you know, they have the information that they'll sign off on the waivers, and anything you get from that, you guys can consider. So you've got coverage there. But that would be more of a department concern. If it's presented to you and it was out of queue, that's between them and either their attorney or the department. You guys don't step into it just because you hear it or accept it. But I appreciate your concern about that. It is an issue. It is a current issue for sure. Like the Howard Center, as an example, if the release doesn't say Department of Corrections and Vermont Superior Court, then their people won't come up and testify and talk about how the individuals are doing in their casework. So that's a real recent example of kind of that, because the Supreme Court has said, got to lock it down.
Interesting.
How about a violation based on his refusal to sign his waiver to a treatment facility?
Well, again, the cover there is typically on the sentencing mitt. It's on the sentencing mitt, right? So it's got to be connected to that, you know, that piece. If that piece isn't there, then you can't get them. You can't force them to sign releases
It's in our
anyway.
condition too.
It's a
that they,
condition of,
But yeah, it's a real slippery slope
Yeah.
as far as release of information. I think in part because we've gotten really accustomed to just, if you're on supervision, if you're going to go this route, then you've got to open up yourself to the world. And you know, the climate has changed on that as far as people, what they can access about you. So, but the other side of it is you're going to see, I think, more risk containment designations, more individuals not having as much opportunity, maybe in some situations, if they refuse to participate in a meaningful way. Because that's really the only other consequence. If you're, you know, you've got to give up some things if you want more freedom after you've been sentenced for a crime. It's just the way it works.
Good. Thank you. Any other thoughts on that issue? Next up is our housing and other updates, a constant issue.
yeah, Lori, I think you wanted to talk to the board a little bit about housing. That's why I put it under legal, but I couldn't remember. And then anything else that you had, I didn't know what you had on your agenda to speak to the board about.
Sure. Well, the only thing, I just want to back up a little bit, and I should have jumped on and asked Meredith to stay on camera. Little frustrated with victim services suggestions this morning. That information being presented to you maybe isn't the whole picture, or I think her words were as what she believes to be behaviors you should consider. I just caution you on that. Your standard of evidence that's required is not it's not argument, shouldn't be based on just argument as to what victim services advocates perceive to be behavioral things that you should consider. I don't want to, they provide a vital role. They're very important. And I understand they're often, like clawing to be at the table, and sometimes they should be at the table and they're not. I concede that. But at the end of the day, it's inflammatory evidence. When someone says there are things that I think you need to know about behaviors, that's a red flag to me. It's we can all make opinions and formulate what we think based on what we hear. Without the evidence that supports it, it is purely conjecture. So I just caution you to, when any suggestion that the department isn't presenting the right information feels undermining to the POs and the caseworkers and the work that they do every day, all day. And just be mindful of the fact that the victim services folks are often triggered into duty at the time that there's a notification that individual potentially is going to be in front of you. That's a whole different context than what the violation is that you're looking at, or the review that you're looking at. So I just be cautious to where you put your where you hang your hat on that information. So and just so you know that when individuals are violated or otherwise alerted, or have been alerted that they're going to be a violation, whether it's probation, parole, or furlough, victim services are looped in on that. So I felt that information was a little misleading. But I'll follow up with Meredith and try to get that clarified for you, but that's not in all the case. I'm part of that process from time to time. So just be mindful that when someone chimes in on what they think you should need to know, but it wasn't in the underlying presentation, the POs in particular on violations are looking at the rules you laid out. And they're saying, hey, we think they violated these rules and here's why. And that's part one. And then what would happen, if you decided to continue on parole, or if you decide to grant parole, what would happen after that and what that would do to the victim is certainly highly relevant, very important. But just be mindful that it can be not meet the evidentiary burden. So on the housing issue, I'm more of a not specifically about that. I know the entire legislature is trying to figure out on this housing issue on what we do. It's really difficult where to put people and what that means for them by way of their programming or their risk reduction. I think what I'm seeing as a trend that I'm just curious about is more so the delays. You grant someone parole and then you indicate, if you do X, Y, and Z, you can come back before us and try again. And that's, kind of intimating that the person will have another shot if they jump through more hoops in a period of time. But there's a case staffing process. If someone loses their parole status, they go through a case staffing process, and it most likely would cause them to have an interrupt or not otherwise be eligible for something. And that delay kind of just puts a kink puts a hiccup in the system. So I just, using that, kind of come back and see us if you can polish this up a little more, if you can use that sparingly on special occasions. I think you'll stop the frustration. You hear Meredith said earlier about how many times the victim has to come back. The amount of time, the amount of opportunities that people are getting based on these little tweaks is causing more stress to the system than not. On the housing condition, again, I know, same thing that I talked to the department about. to me, there's got to be kind of a ranking order on housing condition. You know, what's the risk? What's the risk? What's the population that's risk? What is it? Is it, you know, the individual? There's another piece on housing vouchers for the hoteling program for economic services. A lot of individuals I think are offering up or are going to be offering up to you that they can get that voucher for up to a 90-day period, 89-day period, which is accurate. The problem is the department's not going to let someone go to a hoteling situation. It's temporary, and there's a lot of other people there that provide risk and opportunity usually to the individual, depending on their fact and circumstance. The other piece that people don't know, that if you apply and get a voucher, we've had a couple try to sneak in the phone call and get the voucher approval lately. If they don't show up at the hotel the night they get the approval, they get a period of ineligibility for 30 days. So they've ruined their opportunity for at least another month. And so, you know, I'm trying to get through prisoners' rights to get a message to them. They don't try to be tricky on that, because that's going to hurt you in the end. But people are trying to be creative on the housing piece. And you know, if you're going to take a risk on someone, I would encourage you to really look at what, you know, housing plan that they, I think there's going to be more pressure. There's this balance between public safety that's coming out. Obviously, the Harley Breer case has incited a riot on public safety. But so you're going to see, I think, reaction to that in some of these cases, probably a more conservative approach to your condition violations, I'm guessing. But on the other side, you still have to balance the, you know, reintegration of the individual, success rate, how long they've been out, and really how well that they did, or why did they lose their housing that they had in the first place. Because there are a lot of situations where it's sort of no fault of theirs. Many that is their fault too. I get that, but so the delays that you build in when you guys are being kind and indulging people and allowing them the opportunity, just know that's likely to put kind of more clogs in the pipeline moving forward.
One of the tricky things, Lori, is we're more often than not being requested to use our current condition 16, which is approved housing. And if the offender is a low risk offender with other options, in many cases, it precludes them from taking advantage of those other options because it's not being approved. So it's a kind of a delicate, do we let them languish until an approved residence has been there, which in some cases 4, 5, 6 months, or do we take a chance and release them to the residence that they proposed, understanding that it may not pan out, but at the same time, their risk is much lower than some of the other types that we certainly recognize and want to be cognizant of.
I mean, I think that's the best you can do, right?
Yeah.
Is analyze that, and part of it becomes you know, and I guess the follow-up on that is that if you give an individual a shot in that manner and they come right back and you see them in 30 days, see them in 60 days, even they abscond and you see them a year from now, just remember, you know, the record needs to show that they've had an opportunity and you gave them the chance, and I don't know that you'd indulge them the second time.
Yeah, absolutely.
It's the repetition that's really causing, I think a problem.
And it's I mean, the housing crisis is real. We get that. And it's just that we very seldom put anybody on parole now without that condition. And no matter what the risk is.
I think I have about 5 or 6 right now, active cases, DOC based, furlough based. But there's one that's on the tier. I think they just pled it wrong. They pled it as though it was a furlough violation, but it was parole.
I'm sure.
But we're talking about that housing condition, and the judiciary, let's say, doesn't align with the administration's position on public safety. They really we get a lot of pressure in court defending these interrupts to explain why we wouldn't let the individual live in a proposed home. Or a lot of it too is how much effort is put into getting them into rehabilitative housing.
Yeah, yeah.
Did we help them with the dismiss application? Did we make sure that, we helped with pathways, whatever the housing piece is. So, but the judiciary, if these get appealed, I'm not so optimistic that judiciary is not going to intervene and say condition 16 needs to be vetted a little bit harder. Then we have you have an example where I just had a habeas case, and the only thing that was holding up the individual was housing. And the judge said, go back to your Department of Corrections, Ms. Fisher, and figure out this housing situation. And the proposed housing wasn't ideal. Department took a chance, and 35 burglaries later, the individual was back in 7 days.
Yeah.
So, I mean,
Yeah,
you get,
well, of course.
it's a tough position to be in. I would just say, all you can do is do the best risk analysis with the information that you have, and the ones that you feel you can take a chance on. And I would get rid of the housing condition or build something else in, reporting requirement, something that keeps them visible. And obviously you can't release people without some sort of residential plan in the
Place to
winter in
go.
Vermont.
Right.
So, but I know it's a slippery slope. It's going to continue to be
Yeah.
an issue. Obviously, it's a huge topic in Montpelier right now.
Yeah.
I just don't think, even with the mandates that's coming down again for the municipalities and their zoning regs and to increase affordable housing builds and fixing the permit process, that's going to take time. That doesn't help you all
Yeah.
right now. So,
Yeah, and the focus is not necessarily on people that are in the criminal justice system. It's just people in general that trying to find housing.
right, exactly. So, and that's certain to become an even greater issue in both of those communities, as we approach, the unwinding of this economic hoteling voucher process. Is, this part one was this fall, this winter, and I think it's going to be even winding down even more unless money is available for that program, which is going to put additional pressure on the system and competition on the system for location. So I think you'll see more of that. But the other, the piece with that too is if you put the housing condition on and they come back to you and ask to have it removed. I know you've had a few of those lately. I don't know what you're requiring of them to prove to you. It's easy for folks to say department's just warehousing me and they're keeping me here, and I'm trying everything and they won't let me out. Again, I would make them prove to you what efforts that they made and explain why DOC and allow DOC to respond as to why that particular housing was denied.
And in most of those cases, Lori, I have to say DOC has done a good job of explaining to us what they're doing and where they are in the process. And in many cases, they're exploring options all over the state, not just in that area that this particular individual is assigned to, but to transfer their supervision.
Yeah, they've definitely been more open to moving folks around to try to, and then that often causes, well, then I'm too far away from my services that I'm required to engage in. So it's a movement usually of those services as well, which takes time. So, but yeah, I think, the burden is really on folks. And the other piece too is to work on long-term sustainable housing. And to do that, someone needs to have a job.
Yeah.
And someone needs to be, successful in that world. So I think there's creative things that we could do to encourage people to not just look at, apartments.com. But I think at the end of the day, there's just not enough transitional housing programs for the population that we're trying to serve.
Good point. Any other thoughts on housing?
MJ, was there anything else that you and I talked about recently that you wanted me to?
I'm trying to think. We've talked about so much.
It's been busy. It's been busy
We've
lately.
been on speed dial with each other, I think, lately.
It's been a lot.
The one
Been a
thing,
lot.
Lori, before you leave us, if you're planning to, I know a little further down, we're going to be looking at our conditions update and be talking with the rest of the board on that. But there was one issue that came up in our discussion, MJ and mine, with DOC, and their proposal was a modest change to condition 1, which we reviewed it pretty carefully and we're not supporting it, but wanted to get your thoughts on that as well. I'm not sure if MJ, you had a chance to talk to Lori about that or not.
I did not have a chance to talk to her about that one.
The rest of them we all agreed on. It's not an issue, but the change that was proposed for us to consider was in condition 1 to simply say that you shall not be cited or charged, period. with any
To make it the same as the furlough condition is what Gary and Kathy had asked us. I don't have the exact language. I'm looking for it.
You shall not be cited or charged.
There you go.
With an offense. Yeah.
And then
So-
it goes into you shall not commit as well.
Yeah, I
think.
mean, I think the problem that we're seeing, so we defend C1 for the department daily. The bench right now is split on that. And I would say the newer judges are starting to align with if the behaviors described and the incident described and the information they have rises to the level of a crime, then the courts are going to consider that to be a C1 violation with that language. I will tell you that they are wholly rejecting just because you get a citation, you violated condition 1. So, you know, I'm with you on your unwillingness at this point to adopt that condition because I think it's going to change anyway for the department. And it's a real tough one because the pushback on it is that they really want the department and then you guys in that situation to be the judge, jury, and convictor of the individual, and that's not our role.
Right.
And so we've been pushing back on that and saying, no, you guys, the court has to make that determination based on the information we presented you. And most of the bench, we've got one holdout judge who's absolutely like, unless they're convicted and found guilty of it, I don't want to see a C1 on there. So that's one extreme that we're seeing.
Yeah.
And then, the majority of the bench at this point, it considers it to be a review of the behaviors. So C1, I think is probably going to change in the near future anyway, for what that's worth for your consideration. But I think at the end of the day, if they have a citation alone, and again, depending on what county you're cited in. So, if you get a citation, obviously something wasn't serious enough that they arrested you on the spot and took you into custody for fear that you were going to hurt yourself or someone else, right? Mm-hmm. So you flash cite somebody in a situation where you can let them go and they have to report to court.
But even in those cases where we've had violation hearings, it's not unusual to have obviously the police affidavit, and in some cases the confrontation with the officer there detailing what happened. And we're looking for a simple preponderance of evidence that violation occurred. And it doesn't matter whether they were cited or not. It matters whether there's enough information to believe that this happened.
Yeah, and I think it comes down again to the behavioral analysis. Yeah. It used to be where you could just, if you were around an incident and the police were there and your name shows up in something, that's enough that you were too close to bad facts. Yeah. But it's a much higher burden now. And to me, for parole violation in particular, it's, we asked you to stay away from criminal behavior. And clearly there's enough information here that you behaved in a way that rose to that level. So you know, I'm kind of with you with holding your ground on it. I think the alignment suggestion from the department was to make it easier to
Right.
reconcile between the two. And then everybody's on the same playing field with the difference. And then it's not a competition of furlough versus parole either. But I think at the end of the day, it was just a suggestion to ease it up. I will just tell you that C1 is debated all the time.
Sure. Yeah.
I
So-
believe it was if I remember correctly, they were making this request of us to make it easier to bring they were trying to adjudicate condition 1 violations quicker. I don't
Yeah.
think they're liking the postponements of condition 1 violations as they're going in conjunction with the court cases. And I think that's why they wanted to add the site language to try to resolve these quicker.
Yeah, and I think it's just it's likely to cause you the same debate that we're seeing on the other side of things. Because prisoners' rights is very in tune to C1 and what the level is. The struggle on it for both the department and prisoners' rights in these cases is if it goes fully to, if you guys postpone the parole part of it, the individual is on a no bail, you know, a citation from the court, and they're on a MIT that they're not going anywhere. And prisoners' rights wants to wait it out for their client and go through the other trial, your job will be easier because they'll likely show up with a guilty or not guilty adjudication. And then there's really no, if they've been adjudicated as guilty, you guys accept that sentence, that ruling in that sentence. And then you can move forward with your disposition at that point. So otherwise it gets back to what we've been talking about for many months now is confrontation and you all being the mini trial. The other piece too is that the department's attorneys, the ones that are on my team that assist, are communicating with the state's attorneys if a victim's going to be asked to come testify for you and they haven't testified at trial yet, because we all know what that does to people that have to do it several times in front of the individual. So we're having communications with the state's attorneys to let them know. Good. So that everybody's on the same page, because the last thing we want to do is poison any well for a prosecution because of you know, the parole board proceeding, particularly when the individual is being held pending trial. So yeah, I mean, I think you know, it's up to you at the end of the day. It makes sense to align the conditions, then everybody knows what the conditions are in your world or theirs. But I think at the end of the day, there's always going to be a challenge to that condition 1. So it makes sense, your analysis of it, in my mind.
And being cited or charged is important to know, and it always is presented to us in that. It's part of that condition. It's not saying we're not considering it.
And I mean, it's usually when you see that, that's just not it. There's other things that come up, right? There's other conditions that have been violated at that point, you know, whether it's curfew, loss of programming, absconding, all the things. So you've got a whole, you know, it's not like it's just, if they're coming with just a C1, that to me seems like a one-off, but I know you see it, but it doesn't seem to be as common.
Sure. Thank you.
Yeah, and I just want to be clear that if there's a continuance on parole or a denial of parole, but a little caveat written in your findings that they can do something to come back, they're going to glom onto that and come back, which is fine. It's what you want to do. But that does trigger your decision, particularly on a revocation, does trigger an internal process at the department. So there's going to be something addressed, whether it's additional programming, whether it's more, you know, risk services, whatever it may be. It's gonna still stay in motion over there, but know that they're hyper focused on thinking if they get back in front of you in 3 months and they've somehow cleaned up what they last presented you, they tend to forget all that other stuff that's happening. And it's just going to make it more, like I said, clog the works for you. But so I just wanted to be mindful of that.
And thank you for bringing that up, Lori, because I wanted to, that we're going to address it. We're going to see this in our reconsideration later. One thing I want to flag for the board is when you're making your decision and putting out your findings, to try to keep timeframes out of when they're going to be back before the board, because we don't know when what the case staffing, you don't know when somebody's parole is revoked, what the case staffing decision is going to be. An appeal may come before you and say, oh, I'm recommending a 6-month interrupt. They've already served X amount of time. However, when the case staffing committee reviews it, they may give them a 1-year interrupt or more. And that's something that happened in our reconsideration case. So I just want to caution you in your language to be careful with that short time of, oh, we'll see you in a short period of time, or such. Just trying to keep that time period out of your decisions, because we don't know what's going to be coming on the other end and what the recommendations or when DOC is going to bring them forward, because the individuals, the incarcerated individuals, are hanging right on to that little piece of information, and then going to be like, well, how come nobody's bringing me back before the board? Why am I not doing this? So I just want to caution that as well.
And I'll get out of here with this. I just want to be clear that I'm aware that the department has submitted communication or other both written and on phone calls to the board in various cases to explain maybe the department's position or what review that the individual might be going under. On behalf of the parole board, I have talked to the department about refraining from doing that moving forward. I don't think that's helpful to the process. They have an opportunity to present information to you through their officers when the matter's before you. You guys often invite them to submit information at times as well, and that's their opportunity to do that. So these kind of outside, we're reviewing risk designation, those, I've addressed that with the department and asked them to stop doing that. So as your attorney, it's important to me to keep your process kind of scrubbed of other influence other than what's on the record before you. So I just, and again, I'm not implying that there was any sort of messaging in that, but as a lawyer seeing that kind of stuff, it made me kind of defensive for you all, because I'm like, let them do their job with the information that's presented to them and let them go. I will tell you though, the department is revamping the risk, their containment policy and their risk designations, and the likely to be more individuals that will fall under that criteria are reviewed maybe in a different way. So you will hear more of that information from the officers when they bring stuff forward to you. But that's a policy change, and I don't think it's been published and final yet. MJ, we haven't seen the final rule yet, right?
Yeah, I don't believe so. This is similar. So for those who have been around, they revamped their level C designation, and now it's called risk containment designation, I believe. And it broadens it more, I think, so more individuals could potentially fit the criteria to be this designation. I haven't seen it since it was in draft form. I know it's a committee that reviews the designation. I think there's an appeal process built in, if I remember correctly.
Yeah, they get due process, but if it is thanks, MJ. It's formally called level C designation. And so that is it's the highest risk designation given to an individual, which when you have that designation, there's less opportunity available to you under certain things. So there is a due process right. If you get designated that, they can appeal it. And so that's, whole separate process, but you're likely to see, I can see a lot more people going through the designation review now. And
are there other designations than that one?
Well, they've changed it from A, B, and C, and now there's basically a 2-tier.
Okay.
And then the lower level has like subcategories. But I think the review, I don't know, I will project that we're probably going to see an uptick in litigation for a little bit when this policy becomes final and people
It
get
was-
reviewed.
It was actually final in July, Lori. I just
Well,
found
I
it
think-
on their website.
Yeah, I think it's gonna be revamped again.
Oh,
So I think we
of
might
course,
see.
with the
But in
whole,
any event, just know that there's going to be there's going to be more review and more public safety analysis done on the department end that's probably a little more restrictive than you've seen in the past.
I've
So-
also, oh, sorry.
That's
I've also
okay.
heard that they're revamping I believe they're revamping their furlough criteria for furlough release on furlough too. I've heard some rumors about that, and some releases have been held off and so forth. So I don't know what's coming down in that realm either.
Yeah, well, I think they're also their violation policy is also under pretty high-end review right now. So all of that will be coming together, and I think you'll see information presented in a different way to you coming sooner rather than later. But I'll keep, when the rules come out, and keep MJ posted on that. But I just, when you hear those terms and things thrown around, that they're changing that containment. Again, I don't even like the word containment, but that's the word they picked. But it's just basically identifying individuals that are at a higher risk to the public should they be released to the community.
I just wanted to mention too, Lori, that one of the things that's really helpful from my perspective, and I think most of the board as well, when we're doing parole reviews and there is a reference to a central case staffing, having that report provides a lot of additional information that we didn't normally get, and really appreciate that. And a lot of times it references the level that they're on and the reason they're there. So I suspect that will change with this new designation to some degree, but those reports are very helpful.
Well, I appreciate that. We're working on to tweak them all the time to make them more clear, a roadmap to both you and the judges. On Rule 74 is when there's a furlough revocation appeal. That is the main record that the judges rely upon, is the case staffing record. And so you'll see information change and evolve, and hopefully, if we do our job, get stronger each time you see them. But the reason that they do change and the formatting changes, and you'll see different language, particularly in the findings section, that's really, at some point, love to kind of go through a case staffing form just generically with you and see if you have any specific questions. But, officers, we're trying to get them uniform, but they all write them a little bit differently. But the key at the bottom is what the case staffing decision is.
Yeah.
And that I would point you to as being, and if the judges get their way, it's going to be very clear as to what information above that finding was, relied upon when they made the decision. So I think that's really important for you guys to know why they did what they did and what information that was based upon to help with your decision making. So, yeah, I mean, at the end of the day, the department goes through a tremendous amount of risk analysis. And I know it's easy when individuals come before you and they're in that fight or flight mode, that they haven't done anything, they haven't looked at anything. It's constant. It's constant review of these individuals. It's constant review of what their programming needs, constant review of their behavioral improvements or not. And so that staffing report will reflect the most current information on that piece. It also, their risk scores, as you guys know, are on there. That's important to know the band. The judges rely on that heavily, on what band that they fall into. And And so, yeah, I think you'll see that improve even more, but I'm glad you guys are getting them more frequently
Yeah.
now.
Yeah.
Good.
Thank
And
you.
if there's other information that you all rely upon and see, MJ is usually pretty good about reaching out to make sure that the department knows about those, but you certainly can let me know and we can work on making sure that the violation files include what you guys need for your analysis.
Thank you.
Perfect. Anyone have anything that's come up that they want to ask about before I get out of your hair?
Thank you, Lori. Appreciate your time.
Awesome.
Thanks,
You guys
Larry.
have a good day. Good luck.
You too.
Hi.
Okay. Roundtable. How are things going? Good idea. MJ.
I added this one because I thought it would be good to have involvement of people actually speaking, because when we're on Teams, I find that we don't speak. There's not quite as much conversation.
Active listening.
Yes.
Anyone like to go first?
We'll speak
Okay,
at
Lynn.
once.
I will speak for the office. The office is
Okay.
very chaotic right now. If you haven't all noticed, there's been a lot of juggling, there's been some process changes with how we get reports from DOC, which has been a little bit of a struggle and a little bit more work on us. It's just hard juggling the amount of emails, the amount of violations. We're doing our best to keep everything as organized as possible for all of you, so so the hearings are pretty well, they keep going, they flow, but it's
Yeah.
just, there's been a lot, and I'll touch upon some of it in number 7, but there's just a lot of work going on up here in the office.
Thank you. Well, I'll just quickly go from my perspective. I appreciate the efforts on the office's part. I know a lot goes into it, and I completely understand. I know that I'm spending a lot more time than I ever have in the past, but it's been going well. I mean, I think some of the things that we've evolved into are very helpful. We were just talking about the case staffing, and I know that others probably see the same thing. And when I start to review a report, usually it's the day before and I see a case staffing reference and it's not there, I'll get MJ a quick note, and before long she has it back in there so that we have an opportunity to review that. And in some case, I don't expect you guys to know ahead of time which ones are missing and which ones are there. It's up to us to figure that out. But it is very helpful to have that information. And anytime there's additional stuff that needs to be put in a report, like a statement from a victim or something, the office is really good about letting us know, the people that are on that hearing, that there's some more information to review before the hearing. And I appreciate that.
I will say, the earlier you can let me know that something is missing, the better. I
Yeah.
prefer not to be noticed at the hearings or before the hearings. So if you have questions or seeing something, if you could drop me a note or give me a call, that would be much better than waiting until hearing morning, because hearing mornings are absolute nuts. Just trying to get into the office to get prepped for the hearing and so forth. So if you see something, have questions, the earlier you can pose it, the better.
Great. Pat, how are things going?
I don't think I have any complaints.
It doesn't have to be complaints.
No.
What, MJ?
It doesn't have to be complaints. This is
No,
just
I'm
like,
just gonna say, I agree that the office does an incredible job. I see that every hearing day. To me, their job is very difficult. They have a lot of juggling to do, and they do it. And very seldom are we lacking anything. And I think that's great. So I don't have any
Thanks.
complaints.
Okay. Katie?
I think it's all like the only thing I have is just about me. Like I think when I'm trying to not struggle with as much as um not sort of putting my like professional hat on during some of these hearings and letting that sort of cloud my judgment and the questions I ask and that kind of stuff. But
You ask good questions.
Yeah.
I do, but sometimes I feel like I do it more from like the
Yeah.
mental health therapist realm than like, you
You
know,
wanna dig
diagnosing
deeper.
realm and that kind
Yeah.
of stuff that shouldn't come in. But
I'm sure it's difficult. I mean, we all have different interests and backgrounds and things. And
yeah,
for you not to be diagnosing and looking at what a person needs for treatment versus your
yeah,
role as a board
Yeah.
member to make a decision on what's presented. And
that sometimes. So I'm trying to like remember the scope of like where I am. And it's hard because like some days I'm literally going from like one job right into this
Yeah.
or like from here right into the, you know, so it kind of, but I'm working on it.
okay.
But other than that, I think it's been since May now I've been doing this. I've just been finding it so interesting, and I'm definitely learning something each week as
Good.
I'm doing it. And I'm definitely not afraid to ask questions. So
Good. I don't think any of us are bashful. That's the good thing. Lynn?
How's it going? I think it's going well. I will say that I do struggle with this idea of dropping 16. The housing thing, that really bugs me. Letting
I have to
someone out
step
on the
out for 1
street,
second. Sorry.
letting someone out on the street with no housing. We had one, I don't remember what board it was, but it was like his dad was gonna pay for the hotel for a month. And it was just very floppy in my mind. It wasn't a secure housing thing. And so I will, in my head at least, kind of say that, well, this is going to go to hell, you know, or this guy's going to be back in front of us. And I get into this slightly negative rotation of thoughts when we are faced with a, can you please drop 16, or this person shouldn't have 16, and the various arguments for and against the housing condition. It's pretty heavy duty, and I mean, we just had it from Lori. It's a big issue right now, and
Yeah.
but asking us to drop it to me that's a hard one. That's a hard pill for me to swallow, to be honest. That one probably bothers me more than any of the other ones. And there's been a couple of days, I will say, that I've been on where there's like 8 SDMFs to do, and that's a lot. I don't really enjoy having to do that many. I'm okay with like 4, but when there's a lot, it's a lot to fill out on top of reading everything. And it's a lot of work. It feels like homework. And since I'm not teaching anymore, God bless it, I do not miss homework and grading and all that bullshit. So the fact that this feels like homework and more work it's a little bit of an uphill struggle if there's more than 4 or 5 SDMS.
Yeah.
So, but other than that, I think it's going well. I do have to be at work at noon today, so if we go late, okay.
We're gonna be done by noon today because I don't have time to go past noon and be ready to go to the legislature tomorrow.
Yeah, I'm sorry I
Sorry.
was late. It's just one of my functions at work is
No worries.
FEMA buyouts and they now cut the money to FEMA. So I have a huge problem on my hands right now. So sorry
Got it.
about that.
That's okay.
Thank you.
Thanks. Wayne?
Life is good. I agree with Lynn on the amount of cases sometimes with this new data clerk entry that we've become, which I'm not even going down that road, but I agree with Lynn. I think there should be a limit on the number of SDMF cases per schedule. Other than that, life is good.
Thank you. Tom?
No, I always do mine a couple days beforehand, and and the office has been great when I have concerns on missing something or can't get anything. They've been great. I'm very appreciative of it because that's a lot. For some reason, I always have one that or two that I can't get into, but I don't worry about it, so I take care of it. So no, I'm living the dream.
Good to know. Thank you. I know one of the things that has come up from time to time is, and I'm sure it's happened to all of us, is once in a while we'll get somebody from corrections reaching out to us individually. And when that happens, it's really important that as board members, we not participate in getting involved in a discussion about why we made a decision or why we're doing whatever, to refer it back to either MJ or myself so that we can speak as a board and not be targeted as individual board members for different reasons.
The same thing goes if maybe a state's attorney or so. I've heard that state's attorneys have requested board members' information as well. It goes for anybody.
Yeah.
Nobody has ever reached out to me, which is good.
Yeah.
I think they'd be scared to reach out to me, I think, so.
Thank you. Okay. MJ, do you want to review the
Yeah,
proposed
I'll try to
updates?
do this pretty quick. I just wanted to just go through a little bit because I don't know if we ever formally went through some of these latest
Right.
changes that I've done administratively, and you all have done the proposed resolutions for violations. I just wanted to talk about kind of how those are going. I see it as a good process. If everybody's in agreement, I think, and then having you all review them, but I just wanted to just touch on that real quickly. If there's any more information that you need, so forth.
The ones that I've seen, it's been great to have that worked out ahead of time and then the details put in the report.
Yeah, I've always had all the information I need.
Are you involved in it directly, MJ, or do they just contact you when that occurs?
They contact when it's occurred. I'm trying to limit the office's involvement in a lot of processes and just having the two attorneys work out all the details ahead of time. Same thing goes for continuance requests, which are the biggest thorn in my side and everybody's side. So what we try to do is so I'll just piggyback a little bit on continuance requests because the proposed resolutions and the continuance requests kind of go hand in hand with the timeframes. We ask for them to be submitted 4 business days prior to the hearing. And the reasons for that is because we have a obligation to have our final schedules posted 48 hours before the hearing. Due to the open meeting law. So this way it gives us enough time to review the requests, decide if we're going to accept them or not, and adjust our schedules. We also have been trying to issue subpoenas at about the same time with that 4 business days. However, we can adjust that as needed if there's an urgency to get a subpoena or there's a hard to find witness or so forth. Because there's so much movement with the postponements. That's why we don't want to be redoing subpoenas all the time if we know there's going to be postponements. We also don't want to waste time for people who have been served a subpoena and then the case gets postponed and so forth prior to the hearing. So there's so many moving pieces. The one thing that was discussed on Friday when I met with prisoners' rights and Lori to talk about what happens when there's a continuance request presented to the other party, but they don't respond. Either it gets lost in their emails, they haven't heard from DOC by the 4 business day deadline. And it was decided to be similar to the courts that yes, the other party's input would be great. However, we would look at the totality of the circumstances, what the request is, and then look at postponing without their input, knowing that the other party's well aware that we will consider it without the other party's input. Because we had a lot of just the holidays, but the holidays aside, and just I think everybody's caseload's busy between parole board and civil cases. And that's been really hard. And it was getting to the point where I was struggling. I know Colby and Carla are struggling too, doing the schedules of the constant back and forth, trying to figure these out. And so I'm just trying to take off a little administrative burden.
And the process still continues that if the request comes in later than the 4 days, it's going to be decided on the day of the hearing.
Unless there's an extenuating circumstance.
I'm wondering, MJ, if those kinds of cases involve victims as witnesses, that there's a way to notify them at the time.
Yeah, and I try to look at the totality of the case and who's been subpoenaed, who hasn't been subpoenaed. And sometimes I've looked at the case, and if there's agreement, I just won't have it go forward. So we don't have the victim in all of that present.
Good.
But sometimes we just don't know.
Right.
And that kind of goes into the list of, it goes into D with the witness list. I know the court gets witness lists. I've asked for prisoners' rights and DOC to provide me with witness lists, or the office. So that way we know who's coming on a hearing day prior to the hearing. Because it's really difficult when you've got all these people in your lobby or in your hearing and you don't know who they belong to or what. So I've asked for some courtesy around providing those lists because it'll help. It kind of goes hand in hand with our YouTuber knowing who's around and who's coming and so forth. And it helps with admissions and so forth.
And if you know what part of the issue is theirs to testify to, it helps us narrow that down so we don't hear it 5 times, that kind of thing.
Yep. And it'll help me, and it helps sequester and all that fun stuff that goes along with everything.
Right.
Morning of, we've got Hope Love and so and so and so and so and so, and I only use Hope because she comes often.
Right. Super.
And then the other thing that we implemented, and I will point to Dean and Pat on this of how it's going, is we've been inundated with arrests and lodgings. So many, either through warrants or through emergency arrest, we've had an uptick in probable cause bail hearings. And to try to simplify that process, we instituted that we would have a PC bail hearing day every Friday morning, and that the Friday before your 20-day mark, we would automatically schedule the person for a hearing because we were chasing attorneys around asking if they're waiving probable cause or if they needed a hearing and so forth. And then this way, we're not chasing people anymore. Oftentimes, sometimes they will come off the schedule, but it's just just helping us keep more organized as an office and not having to chase people. And it seems to be going okay.
We used to call that arraignment day.
Well,
You're right, Wayne.
Yep. So every Friday's arraignment day. And so
I've had 1 or 2 of those stipulations, and again, it works well when they hash things out.
Yeah, and we also, I kind of did it on my own and asked for forgiveness later from Dean of letting bail it's kind of like proposed resolutions, but having bail stipulations that if everybody's in agreement on bail, why come forward?
It's great.
If you've
Yeah.
worked out a good release plan prior to a violation hearing, what's the sense of having it come before a board member for signature when we can just take care of it administratively? I know a few times I've also had cases where with warrants, I've had the same thing where somebody's finally appeared, they've worked out with a plan with their parole officer, and I'm withdrawing the warrant and canceling the warrant instead of having somebody arrested. So I think trying to get some of these administrative processes down is helpful, I think, for all parties too.
Absolutely. Thank you for
Because
doing that.
it's just getting more complicated in some realms.
Pat, working well for you?
It is. It's nice that you and I are flexible with each other on Fridays.
I don't know if
Yeah.
Colby's contacted you all, but we do need one of you this Friday. I think she was going to contact Pat.
Yes, she did contact me and
Okay.
She did? Okay.
Because we canceled yours last week because we actually had a Friday with no hearings.
I know.
Kind of weird.
Great. Okay, let's finish up on our conditions discussion, and hopefully everybody had a chance to review hopefully the final analysis.
Yep.
And we did have some thoughts from Lori today on the condition 1 thing, just kind of as a reminder. That was one of the requests from DOC, was that we add that to our condition 1, that you shall not commit any act punishable by law, and adding to it that shall not be cited or charged. And the thought process there was, as we've talked about, to simply mean that if you have a citation to appear in court, that means there's a preponderance of evidence that you violated condition 1. And so we have talked about that, MJ and I wanted to bring it up to the rest of the board, and now we've had Lori's input as well. And so as I said earlier, I'm hesitant to support that. I think our condition allows for quite a bit of latitude in terms of violating that condition, but there needs to be some preponderance of evidence presented to the board to find that they did violate it. And simply a citation or being charged without other information just doesn't meet that threshold, in my view. But certainly willing and anxious to hear from the rest of you on your thoughts on this and how we may proceed.
Citation doesn't cut it, in my humble opinion, of course. So.
Yeah, I'm with you, Dean. I'm not okay with it.
Wayne loves condition 1. I can tell. I know from past, and I can tell.
Oh, I'm way on the other end of this, because a citation is merely an invitation to appear at a specific time and place. It has nothing to do with a crime.
Right.
You can give a guy a citation for murder when he's committed disorderly conduct. It's merely an invitation to go to court or appear. It's an order to appear at a time and a place. But on the other hand, this continuing postponing to resolution, as you all know, I have a real problem with this, because criminal cases are dismissed for a multitude of reasons. Multitude. But it still doesn't mean that didn't happen.
Right, right.
So, I think our condition 1 violation should be supported with a sworn affidavit, minimally, if not testimony from the arresting officer or the victim.
Or an admission. And
Done.
Yeah, no. Is anyone in
admission works
support?
best.
Pardon me?
The admission works best.
Yeah, it does. Well, I'm not hearing any thoughts on changing our condition 1, so I'm going to suggest we leave it as it is written. And see if I can bring up that other one.
So if you want me to go along, Dean, we've had an increase of transitional housing / residential programming coming up as in violations when people are bringing transitional housing as a condition 7 violation. PRO has been coming back stating that transitional housing doesn't fall in as a program. So I am suggesting that we edit the condition to say you shall participate in any programming, screening, counseling, and or transitional housing / residential programming as required by your parole officer or the parole board. DOC added transitional housing into their programming conditions. So I
like
didn't
that.
know if this would help because they are signing a program contract to be part of that program.
Correct.
This is good because it doesn't require us to explain it over and over again, hopefully.
Right.
And
Mhm.
I think that's great, MJ.
That's a mouthful now, though.
Is that the same? Is that the same as like a? Would that count the same as like a treatment facility? Because what
Yes.
I'm thinking is it's
Some of them
really,
are.
really important because a lot of like I can think of at least a few that we've just had recently where
Mhm.
we paroled them, but to a specific facility. So
right.
if they leave that facility, that should be something that we should be able to violate them on. So I think that's good.
Yeah, I consider that residential programming.
Okay.
Yeah.
I just wanted to make sure they're the same because
Yeah.
sometimes I don't remember what condition that is, but there's a condition in there where they're released only to.
We're adding that one
Okay.
That's a
special as
special
a special at
condition.
the end.
That
But
would
the
be a separate.
the participation would fall under any programming, but I think adding the specific language gives us a little bit more protection
Right.
around this and also helps with the integrity of these programs as well, because I think that's where a lot of it was coming into play was you just want to say the person has condition 16 and you're trying to bring forward a housing condition, but they haven't necessarily been evicted yet, where this allows them to also look at the programming contract that they signed.
Right.
Treating these as actual programs, which they are. They're not simply just an apartment. Say it's pathways. There's other components to it.
So in the next one, condition 10, we took out the first 30 days of parole supervision that we originally talked about, which was a bit controversial. And we also removed it, I think before that was the condition 13, electronic monitoring condition.
We did 13 with Richard, and then 10
Yeah.
when we spoke about DOC, we also found out that they do have review processes for curfew that we weren't necessarily aware of.
In 11, we removed, as you may recall, and we've taken the condition in both what were formerly domestic violence conditions and sex offender conditions and made that a separate condition 11, which is not having contact with the victims by any means. So it can apply to anyone that we want to have a no contact issue with a victim, regardless of what the offense is. So the other two conditions in domestic violence, one was to participate in programming, which is covered under 7, and the other is to abide by any court orders, which is really covered by condition 1. So there's not a need to continue to have special conditions for domestic violence because that's covered under other conditions. So the condition 15, which used to be all of our sex offender conditions, is now condition 14.
Which I need to update section B.
Yeah.
I'll make a note.
And then on condition 15, which used to be our residence condition 16, we're only talking about the residents. We've removed the piece about employment approval.
Hey, Dean, hate to interrupt, but I have to
Yeah.
do my family obligation, so
Okay,
I'm sorry.
that's all right.
But-
Do you have any questions or concerns about the changes in the conditions?
No,
Tom?
I'm very
Or
happy with
about
them, actually.
Okay.
I like the way they're going. It makes more, when it makes sense, I'm happy.
Okay.
So,
And the rest of the meeting will be available on our YouTube channel
Yeah.
later. I don't know exactly when it'll be posted,
that's
but
fine. I had to take care of my 96-year-old dad, so I had to go on. So,
Great.
no,
yeah.
it's
Thanks,
all
Tom.
good.
Have a good weekend.
Anything I missed, MJ?
I don't think in the conditions, and then I just wanted to go talk about modifying conditions after, but the conditions
Okay.
part, I think.
Well, I guess based on this, then, I know we've tentatively approved this. I'd like to have a formal approval of the board for these changes to be the final changes at this time.
Can I just super quickly ask, Dean,
Absolutely. Yeah.
did somebody complain about that? The sentence of you should only work where your parole officer deems it, or whatever, you know, the one you took out of the new 15
Yeah.
was that, did you take that out because somebody bitched or?
No, that came out in our discussion with Richard. And what are we
Okay,
doing with
okay.
that? Has there been any issues? And we really haven't had any.
No, I agree. No,
Yeah.
I was just curious if somebody
Yeah.
had complained about
No, not that I'm aware of.
it. Okay. Yep, no, fair enough.
Yep. Any other thoughts or questions?
I'll make a motion that we adopt the final set of conditions.
Second,
Motion has made and seconded to adopt the changes to our condition setting policy. All in favor, signify by saying aye.
I
Hi.
Any opposed? So we are 5 in favor and 2 absent, but we can count Tom because he approved
Yep.
before you left.
Also, I don't know, I don't have an effective date right now for these. It might take me a little time. I need to
Yep.
contact DOC about having their offender management system updated. They also
Okay,
had talked to us about potentially having some parole agreements updated to make it a little less confusing with violations. So, I'll come back next month with more around an effective date.
okay. So we'll just hold off on these are approved, and when the effective date is ready, you'll let us know and we'll
Yep.
begin using them then. Thank you.
Yeah, I think there's not significant changes here, for the most part, so I'll
Okay.
keep you updated.
just to be super crass, but they just changed all federal forms to have a third gender, which is non-binary. So I'm just floating it out there that
Yeah.
15J that has you shall not initiate or maintain contact with male, female, or male and female. We might need to add non-binary. I'm just saying it out
Yeah.
loud.
Yep. I hear you.
So I will say, if you look at the DOC's offender management system, they have a
They
lot
haven't
more
changed.
genders than just those 3 in there.
Oh, yeah, no,
So, no, I
it was
just
on
thought
the
I would,
news. Yeah,
yeah,
that they added non-binary. I agree with you. There's others,
yeah.
but I'm
So
just saying
I
that might come down the pike eventually.
Yeah.
So, but yeah, no, I approve for sure.
Okay. Let's look at the modifying conditions of parole change.
And this, I think it was this we talked about briefly, I think when Richard was here, around having a prior to a condition modification hearing, allowing a condition to be temporarily modified. It's similar to I would say conditions of release. In a way, when we release somebody pending a violation. So say there's something that could be more immediate instead of waiting a month for a hearing. The chair or I could look at it to see, do we want to approve this until a hearing?
Yeah.
So say somebody's out of bounds, they're trying to do corrective behavior, but they don't have condition 13 and they want to do some electronic monitoring, or they've been drinking and they want to put scram on it. That's one example. Just kind of a informal, more of an administrative process to modify a condition before having to allow it to be more quicker,
Right.
and then have the formal process, whether it be through a condition modification hearing or a violation or a reprimand hearing.
So you're saying they would come to you, the PO would come to you and say,
Mhm.
I need this condition now. So it would be
And
up to,
with justification.
Yeah.
that's what I was just gonna say.
Yeah.
You would
Yep.
ask for their justification to make a determination based on that.
Right, and it would be temporary until the next hearing
Right.
day.
I think that's great. I mean, why wait a
And
few
that's
days
something
before
DOC's
we have
been
the
bitching
hearing?
about.
Exactly. There was concerns from DOC if we went to some of the other issues we were talking about, they
Right.
would have to wait too long a period of time before they could modify a parole agreement.
Right.
And this,
Mhm.
Because
I
Yeah.
think that's good.
if the person starts sliding down the slippery slope and they gotta wait
Yeah.
a month.
Yeah.
But I have a question for that.
Yep.
So here we are and they put scram on the guy. And now they're waiting for the next hearing for Buck or whatever. What if he like straightens out in the meantime? Because that is now a temporary condition, can the PO elect to sort of not
Okay.
come in front of us and be like, well, it took 2 weeks, he straightened himself out, he doesn't seem to be drinking anymore. I don't want to do the condition modification hearing in front of the board.
Yeah.
Can
good
they
question.
opt?
I
And they
think
Maybe they would
I
have to.
I think that's a good. I think it's an idea to have the opt out. I don't think it's going to get used very often because I think they're gonna you want that. If they've used that tool, they're going to want to keep that tool. So I think they're
Sure.
going to come to the formal hearing to
too.
request that it stay. But I don't have a problem with
You could
having
add
an
a
expiration date on that form that says
Or-
this condition expires on such and such date, and if they
Or just
don't
simply
want to.
say, MJ, that the supervising parole officer may withdraw the request for modification prior to the final hearing.
Yeah, that's not
Yep.
bad.
Don't they already have this ability by sanctioning?
No, because they don't have controls of the conditions. They can't if they don't have a condition to say, I'm going to continue to use electronic monitoring. If
Well,
they
I
don't
think-
have an electronic monitoring condition, they can't sanction by putting electronics on somebody without that condition.
They have this ability if it's furlough, Wayne.
Right.
No,
And that's
I've
the-
read many parole reports that say I'm finally bringing it as a violation because sanctions haven't worked. So I just
Right.
understood what MJ said, and I don't think it's gonna be a big issue, and it's probably really not worth the time we're spending on it. But if you do this, how many times and for what time period? Because, yep, he's all straightened out. I had him on this temporary for 2 weeks. After he says, that's good, I'm removing it, week and a half goes by, same behavior. So I'm gonna sanction you. If you do this again, I'm gonna give you another temporary. Same thing happens. If you do this again, I'm gonna bring you a violation. I mean, I think there's gotta be a set limit to the amount of
So
temporaries.
here's what I would say. I mean the option. I think I like the opt out option, but I honestly think, kind of going with what Wayne says, I think how we message this, because I think it would be in a case that Wayne's saying, I don't think we should remove that temporary until it's a formal condition modification hearing. And then look at, is this something that should have been on their parole agreement?
Yeah.
I mean, I like the option that we could not go to a hearing, but I don't think it's going to be used very
Yeah.
often.
I see this, and I've said this all along, and I probably won't say it on the record. Let me say this, it's going to be a tool that many parole officers use to avoid coming to a hearing and coming before us. They're just gonna, boom, I took care of it. Very
then
simple.
Well,
Three
and that's
strikes,
kind
you're
of
out.
Well, and that's kind of why I like the idea of having them come to the board for a formal condition modification hearing, or what it is, and not having that opt out option.
Okay.
Because I think I think that way they have to come before the board to ask for this to stay or not stay.
Makes sense.
And I honestly, most of the time we're going to be adding conditions are going to be in response to a violating behavior. So I think they should at least come for, there should be a reprimand or at least a reprimand in my mind.
Yeah, but then it's a reprimand hearing, so that this is a little crack right here that we got to be careful of falling into.
Yeah.
Is
Right.
and
the
that
other,
back to Wayne's point, maybe there needs to be, okay, you're allowed to do this twice, and then you can't do it anymore, or I don't know.
well, the other thing is the condition allows for the parole officer to make the decision to discontinue using it. It's up to them.
Mhm.
So why
Right.
not just, if they
Right.
request a temporary, why not just have the modification? We're not talking about a violation, talking
No.
about a modification.
Yep.
Yeah. And there may be, and who knows, there may be a violation or a reprimand already in the works, and that,
Yeah.
because we do this all the time with releases.
Yeah.
For violation hearings. We have these temporary conditions of release. So I think that sometimes stay, sometimes don't stay. It all depends.
But just inherently in what you just said, temporary conditions.
Yes.
That's what we're talking about. And knowing what I know and what I believe is these temporaries are going to be abused and continue to be abused unless we put a bright line on them. Because when anybody else issues temporary, there's a finality. There's a date when it stops and what the consequences are. Temporary means temporary, not permanent.
Right. And that's why I think having a hearing
We'll
to
just
make
leave
it
it as it
permanent.
is.
Yeah. And then
Good
you have a board
discussion.
of 3 making the permanent decision. Yeah.
And then the process for modifying it?
It's the same process as
Sure.
it was.
Pretty straightforward.
I
Yeah.
just added some
Works
language
smoothly.
around if it's
Yeah.
a temporary request or not. So
Good.
that way we know.
So unless there's any other discussion on it, I would entertain a motion to modify our parole agreement to reflect the new agreement for temporary condition modifications.
They also
So
want to make
moved.
a motion.
Yeah.
Pat has made the motion to approve that. Is there a second?
Second.
Seconded by Lynn. Any other discussion on that motion? All in favor of approving the change to the condition modification section, signify by saying aye.
Aye.
Aye. Any opposed? 5 in favor and 2 absent. Thank you. Okay.
Good job, MJ.
Yes, thank you.
Reconsideration request.
Yes. Dylan Sweet.
Dylan Sweet.
I remember this one. I
Sounds
was
like
on
it's
both
been
of them
adjusted
after
all.
the continuation and everything.
I was concerned. I mean, this is really outside our reconsideration policy.
I thought it might be, but with the
Yeah.
time frame that it came in, I thought I'd bring it to the board.
Yeah. Anyone have any thoughts?
I mean, the only new information that I saw in this
release plan.
potentially is that I think the release plan was presented at the hearing, if I remember correctly.
Was it?
I think the new information was the 1-year interrupt versus the 6-year interrupt. I'm just
Yeah.
comparing the release plans right now because there is a release plan in the folder from the hearing.
Because the release plan was presented at the hearing. That's January 15th, and the hearing
Yeah.
was the 17th.
Right.
So they would have presented all of that. I would assume.
We had a December 15th one. I don't know if there's any differences to it
There's
or
a-
not.
There's a TWI release plan dated January 15th.
Right, and there's one in the hearing folder from December 15th.
Right, yeah.
Is what I just stated.
Mm-hmm.
So I think the screening information is slightly different.
Different, yeah.
So
How much
essentially,
different, I
the
don't
case
know.
staffing that took place after our decision to revoke parole requires a 1-year interrupt. Is that correct?
Yes, and I think that a lot of what Marco was stating in his request for reconsideration is that the board was under the impression that it was going to be a 6-year interrupt and you are hoping for a short turnaround and more development into the release plan. So he's saying he's presenting more development into the release plan and there was a 1-year interrupt instead of the 6th.
Right. I don't recall there being a discussion about the interrupt because we wouldn't know what that's going to be.
So there was, I don't know if there was discussion in the decision making, but there was discussion on the record of the interrupt. I did review the hearing. And that was stated on the record about the PO was anticipating a
Okay.
short,
Very long interrupt.
right.
Any other questions or thoughts on this?
I think a 1-year interrupt is fine. I mean, 6
But-
years, yeah, that'd be a little excessive.
We're not discussing the interrupt. I think we're discussing, do we want to have a new hearing or not?
Yeah,
And
it's
that's,
a reconsideration request.
I don't,
But I
I
don't,
guess
that's what
I'll
I'm
make
saying,
a
is
motion
I'm
that-
fine with it. Yeah,
I don't see a reason for a reconsideration at this point.
So you made that a motion, Pat?
Yes,
Is there a
I
second to
did make
Pat's
that a
motion?
motion.
oh, second.
Second.
Mhm.
Any other discussion? Katie, did you have a thought you wanted to throw out there?
I just remember, I remember thinking during this whole time just how Hope from Therapeutic Works was just really pushing it. I just felt like she was making a lot of promises that I don't know. I wasn't sure how well they were able to even complete this release plan. So I'm definitely not in favor.
Any other discussion? All in
one
favor
other
of-
thing, oh,
Go ahead.
sorry.
That's
One
all right, go
other
ahead.
thing I did see in the email, just one thing to point out too, is there was no residence or a bed date at the hearing, and now there is a
There is.
potential residence and a bed date with V4. And,
I did see that. Yeah.
Yeah.
and I just wanted to just point that out too. That's the only other.
When is the 1-year interrupt
um,
complete? Is it
That'll
June?
take me a minute. Just a second. Oops, wrong folder. He was arrested on October 1st, so I'm going to assume October
Okay.
from the date of return.
Any
Yeah,
other
it's been-
discussion?
Since
go ahead.
October 1st.
Those
And
in
he's already
favor-
missed the bed date. The bed date was January 23rd.
If there's no other discussion, all in favor of the motion to not support a reconsideration of this case, signify by saying aye.
Aye.
Aye. Any opposed? We are 5 in favor of the motion and 2 absent. Thank you. SDMF update. Well, we've had a little discussion about how it's
Yeah.
going. Anyone else have any thoughts on that? It's
I
been a
guess I
while.
forget, offender changes more than I forget anything else.
It's been a while since we reviewed these, and I looked at the report too, MJ, and you had 3 cases you wanted us to look
I
at
just,
some discrepancies. But
yeah, I just pointed out a few.
yeah,
I would say
Um,
overall, it wasn't, looking at the spreadsheet, it wasn't bad, I wouldn't say. The one thing I will say is that sometimes forms aren't being completed.
one of the things I was going to ask on that, and I don't want to create more work than necessary for the office. As I was looking at some, and there were a couple where I had nothing in there, and a couple where I had a couple missing, and I do all mine on, I write them out first, and then I transfer them onto the document, and I go through each category.
Yep.
If I missed one completely, I generally only fill them out if we have the hearing. So if we postpone it or
Right,
they don't
which we
show up,
wouldn't
I don't
expect.
do.
Right,
So
and
I,
we keep those for the next hearing. So we don't
Is-
anticipate, so we're waiting until Monday of the week after. So we're giving plenty of time before
if
we
you get
even look at the forms.
if you get one where nothing is filled out, is there a way you can just send a quick tickler response back? Don't forget this one or something, because I don't remember missing any, but I got 1 or 2, I think, in there where there was nothing on them.
I mean, I don't see why we couldn't.
I don't know if anyone else
As
found
long
that.
as you know we're not looking at these forms until the following week.
Yeah. Other thoughts on that? I don't know if any others looked at the report that was with this.
Yeah, personally, I just forget to go back. Like I have some brilliant idea and then I have an ADHD super moment and I'm like, oh, I can't remember. And then when I try to go back, usually it's been over a week and then you guys have harvested them and I can't get back to that. And
Well, we have them. So if you need to get back to something, we
Yeah.
keep them in their folder. So we have them. So if you have to get back, just let us know.
yeah, I just remember there was one where I was futzing around and it was gone and I was like,
I guess in mine, I take my notes and like offender change, I usually have to wait and ask that at the hearing.
Mm-hmm.
And I put it in my notes and everything else is filled out. And then I forget to go back after the hearing and put what I feel about, how I feel about the offender change.
Right.
And I notice that's where I forget most of my stuff, but most of it I can get ahead of time, except
I-
that one I'm
I
not
can
always sure.
also notice sometimes when people are changing things at the hearing, because I'll have two. Well, if you notice, there's some lines
Oh,
that we
really?
have two
Yeah.
on
Yeah,
that people have 2 boxes checked. So
Yeah, I saw that in a couple with Sam's, I think.
Yep.
yeah.
It happens to
Yeah.
more than just Sam. I'm not gonna put it out for her,
Oh,
just
no,
her.
no,
Yeah. I get it.
But the cases that I picked today, if you wanted to go over
Yeah,
them, I think I picked the
sure.
ones where there was a couple that we had more than one where there was a difference between aggravating and mitigating
Okay.
instead of just one area. There
Yep.
was more than one area.
Well, let's take a look at Jager Burke first.
Okay. So in Jagersburg's minimum folder are the SDMF forms. And I don't know if you want to listen to the hearing or if you just want to look at your forms and go from there.
Let's see.
And where'd you say it is?
So in the SDMF folder within the staff meeting are their offender files, and we keep the SDMF forms in the offender files.
Yeah, I thought I looked and couldn't find it.
And it
Which
looks like
which ones had the discrepancies?
we're looking at Jaeger Burke first.
No, I mean, which category, which,
Oh, yeah, I can tell you that. Hold on. Sorry, Katie.
Yeah, there.
Let me find him first. So it looks like for him, oh, we had 2 Burks, 3 Burks. We're looking at responsivity programming and offender change.
Okay,
with
and I put aggravating.
For responsivity.
Yep. Katie, you put neutral and
I
Tom
had-
put mitigating.
I had neutral because he had completed some, but there was still some that he needed to complete. He still needed to complete risk reduction, but he had completed CSC. That's why I put neutral.
Yeah, and I put aggravating because he was case staff to complete risk prior to release to the community and had not completed that.
That I saw that as neutral because that's like, just because I feel like if he needed to complete that, that probably
Mm-hmm.
wasn't his fault. It's just something that had been scheduled while incarcerated yet to do. So that's why I did neutral, because he still needed to just get into it while incarcerated. So I didn't see that as aggravating. That's why I said neutral on that. Plus, he had done some that he had been required to at that point
So
for the
in
CSC.
In the first sentence of the coding for that, it says the offender has not completed programming based on risk. Either he was not afforded or she was not afforded the opportunity or was assigned to programming but failed to actively complete.
Oh, okay. So even if it's something they haven't been
And then,
afforded to yet,
in
it's still
deference to what
gonna
you said,
count against them.
the neutral says if the offender has completed some programs, but one or more elements of risk were not adequately addressed or no programming was warranted, is neutral.
I would
I don't
almost in
I
this
don't
case,
know how I think it's very fair though that
You know,
if it hasn't been afforded to them,
right.
why that counts against them as aggravating. I mean, I
Well,
still think yes, it should be required, but if it hasn't been scheduled for them yet, why are we holding that against them?
Yeah, and I wouldn't do that either, Katie. I know that in this case, they have not completed what has been staffed for them to do.
so here's
Right.
here's kind of where I would look at it. We saw him, it looks like he had a minimum of November 1st. We saw
Yeah.
him on November 12th. With a minimum of November 1st, he was case staffed to stay in past his minimum to do because they felt he needed to do programming. So
Mhm.
to me, he wouldn't be afforded programming until he's sentenced, and he wasn't sentenced most likely until about November 1st. I'm thinking he was a credit satisfied the sentence probably, and that's why he didn't even have the opportunity because of his short minimum length. And so I would almost take the afforded part, looking at it with my knowledge, I'd take the afforded part out because he had to stay past his minimum in order to do the programming, and he'd have to get in the next cycle, unfortunately, because that's just the way it
Right.
Even though
works.
the criteria says he was not afforded is aggravating.
Oh. And I
Yeah,
would almost
that's why I had a
discount.
question with that.
Yeah.
I didn't like
And
that.
I'm just
would
going
almost
what the coding suggestions are. It doesn't influence the decision to grant or not grant if they're participating.
I would
Right.
I would have coded this aggravating myself probably because he's not in the programming. I would have probably also discount the old CSC.
Yeah.
I need to talk with them to change the drop down of the programming because you see ISAP a lot and IDAP a lot,
Right.
and there's no such thing anymore
They
as
don't
ISAP
exist.
and IDAP. And CSC is so old, and that's not a current thing. So that list that you're seeing in the programming is not accurate, and I need to get that changed because
Okay.
it should be risk intervention services. You should be seeing RIS or RRP.
You can
Mm.
certainly make a case for neutral and aggravating.
Yes.
I'm not sure how you can make the case for
I don't know
mitigating.
how he made mitigating
Yeah.
and without him here.
Yeah. No, I get that.
Because his note said participated in CSC needs to complete RRP, so I'm not really seeing it.
Yeah. Okay, was there another one in that case?
Yeah,
I think offender change, right?
yes.
Under change.
And it's gonna be Dean with an aggravating, Katie with a mitigating, and Tom didn't check the box.
And I said mitigating to that because he, as part of the change part of it, and especially when you're looking at like motivation and growth, is I
Mhm.
think the lens I looked through it. And I remember him specifically saying he wanted to remain incarcerated so that he could complete the programming and finish obtaining his GED because he didn't think he'd be able to do that on his own if he was released. So he wanted to complete programming and remain incarcerated to do that. He was willing to do that, or just to get that programming and to do his GED. So that's why I put it as really motivation and growth.
Yeah.
That's why I put mitigating for that one.
And I put aggravating because, and I didn't listen to the tape over again, but my notes say that he still lets his temper control his violent behavior, which must have come out in the interview at some point.
Well, right. I think it did. And so that's why he was saying, I want to stay in to do this programming to help with that.
I guess I could move to neutral on that, that there's no evidence yet of change.
Right.
I'm struggling with a mitigating too. I was trying to pull up my SCMF stuff. I'm having a hard time with him being incarcerated and getting himself back incarcerated to lean on your mitigating, Katie. I think it's showing some evidence, but I don't know.
I think you're right. I think you're right. I probably should have gone neutral with that.
The mitigating coding says evidence exists to show the individual completed required programming and is displaying behavior change.
Yeah, I think I probably should have gone with more of a neutral of this is what he'd like to do, but now he just needs to show evidence that he's going to carry that out.
Yeah. I could too. Yeah. We both moved towards the middle. Where was Tom on that?
He was absent. He didn't check a box.
Okay. Any other criteria in that case?
Nope, that was it for that one.
Okay.
All
Let's
right,
take a look at the next one.
Ronald Short. So it looks like we got criminal and parole history and ability to control behavior. And Sam's not here to back up her mitigating, but we can look and see if she has notes.
She said that it's because the ability to control behavior is because he's on the MAP program and he's receiving counseling. I would probably have asked for an aggravating on that because there is a history of significant substance abuse.
I would have done aggravating on that.
And Lynn and I went with neutral.
No, somebody had aggravating. And we're looking at ability to control behavior. We skipped over criminal and parole history.
Oh, I was looking at the behavior. Go back to
Lynn had aggravating on ability to control behavior.
I had neutral. And Sam had both neutral and mitigating.
Yeah.
Covering
Assuming
the
yours
bases.
was a typo.
Yeah,
I'm thinking so.
I was looking at, there were multiple crimes as there are with most of them, but there was no escalation of severity.
Okay, so wait a minute. Are we talking about criminal and parole history or ability to control behavior? Because multiple crimes and severity, is that ability to control? I'm just confused where we are.
Well, I moved back to the first one, criminal.
Okay,
Yeah, the
let's go
criminal
back to the
thing.
first one. So Dean's at a neutral, Lynn's at an aggravating, and Sam was neutral and mitigating. I'm assuming her mitigating is not correct.
Yeah.
I'm assuming her should be a neutral, so
So Lynn has written in there lots of simple assaults, which I agree. Are you still there, Lynn?
I am, no, I am, I'm reading because I
Oh, I'm
do
sorry.
not remember,
I'm
I
sorry.
don't remember this guy, like, at
Yeah.
all. I don't
I
know
don't either.
why, this is,
That-
I've suppressed it somehow, yeah, I don't know, I can't remember. But I usually take a fair amount of notes.
Well, the famous of notes are worth the best of memory.
Well, it looks like we have similar responses in our notes. You just
Yeah.
determined it aggravating, and I determined it to be neutral.
Well, because it's like currently serving convictions for SAPO. I mean, there was a lot of simple assaults.
Yeah. I agree that there are multiple crimes. I just didn't see any escalation. They seem to be all the same thing.
True.
I'm wondering if that's multiple. I could see. I don't know what the intervals were, but I'm wondering if it was multiple crimes with short intervals in between. If that might be, may not
Part of it.
have been around the escalation, but
Yeah.
the frequency.
The other thing that I always look at is these majors and minors that he's got in jail.
Yeah.
And so look at the trend there. And the trend with this guy is he's getting majors. And then all of 2024, he's only gotten minors. So that's right. He's getting less, whatever the hell it is he's doing. And he got not guilty on the minor on January 11th last year.
So
We
are
have
you
What?
Are you factoring institutional behavior elsewhere other than that domain?
I'm looking at trend of behavior in anything I can find.
I know, but I want to caution that institutional behavior should stay in that domain and not creep into other domains, is what NIC had trained on.
Yeah, but it's all these simple assaults, and then if he has like 8 majors for the same year, yeah, I factor that in. It's trend of behavior, MJ.
I'm not debating that it's trend of behavior. I'm saying that DRs should not be factored into other domains. It should only be factored into the institutional community behavior domain. It should not be used in your other domains coding.
Well,
So
I have to take it in as part of the picture, and I look at the person as a picture. And
Okay,
there's a lot of-
I'm just reiterating the training that you all received by NIC,
Okay.
and that is what was
Well, I
trained.
think we're,
So
the,
when you look at the criminal and parole history, right there, criminal and parole history, then you look at the little cheat sheet. Age of consent, intensity, escalation, severity. Okay, he hasn't escalated. Violations prior parole, probation, and community release. Continue the assaultive behavior. I don't see how it couldn't be aggravating.
well, the criminal history has to reflect specifically the crimes that they've been convicted of.
Well, it
That
says
category. So
parole,
that's, we're just
probation, and
measuring that
community
category,
release,
and you
their
could make,
behavior.
you could make a case that the criminal history is either aggravating or neutral. I don't think you can make a case that it's mitigating.
No.
I agree.
Okay. And then with DR history, that category takes into account their recent institutional behavior or their behavior if they're on community supervision. And if that's the next one that's different, is that the correct one, MJ?
No, ability to control behavior is the next
Oh,
one
okay.
that's different.
Sorry.
See, this is where I respectfully agree to disagree with you, MJ. That's a training, but I don't know how you cannot allow these to creep over to each domain. Because by the way they've got them listed, they do.
Is this the guy with the folder with all the diplomas? It's coming back to me now. Because I have
No,
written
no.
here as a comment that he's taken, is this mine? Yeah. Parenting classes, violence programming, drug and alcohol counseling, risk intervention, anger management. Like he piled up the classes, and I think he sat there with a folder. He was like trying
Yep.
to show us his diplomas.
Right.
Yeah.
And we agreed on that.
And that was neutral.
Yeah. And ability to control behavior above. I had noted that he had substance abuse issues, but I don't recall there being any violations of probation or parole. And put that as neutral.
Right. So for ability to control behavior, I had Dean with you in neutral, Lynn as aggravating, and then Sam as mitigating.
Well, the reason I have aggravating is because the last time we talked about this, and I was putting neutral on the ability to be hooked, control behavior, I was told that this is supposed to be looking back at the way he controlled, it says right here, threat perception, impulsivity, mental disorder, from previous, not current. That's what I told. It's
Right.
a history.
Mhm.
So the history of this guy is lots of simple assaults, so then he's not controlling his behavior. And are you guys now telling me that we're supposed to look at ability to control behavior in the present moment?
No, no.
Exactly. So that's why I put aggravating, because he has years of ability to not control his behavior. It's
So
never,
these factors are historical and have to relate to the time of the instant offense. So the offense that you're
Right.
seeing them for.
Right.
So what
had
got
substance abuse
got
issues.
them there?
Right.
So
simple
not
assault.
going back I think you have to be careful if it's not going back years and years. It's looking at what was
What he's serving for.
going on
Yeah.
at the time for what he's now serving for. So it's not his complete sentence, it's what the charges that's got him before you.
Which is from the line above, lots of simple assaults.
Yep.
So
And
it's not neutral.
and the behavior thing was substance abuse issues.
No, it was simple assaults. Or yeah, I mean, he's on the map.
No, that's the offense. Yeah. Certainly not mitigating.
No,
Certainly not. No way.
What's the next category? Is it?
that was
commu-
it on this
Oh,
one.
just that, that's those two?
Yes.
Okay, okay. Let's take a look at the other one.
Sarah Guerrera.
I love
Looks
when
like
you ask when you ask them, MJ, how to pronounce their name, and then you have it right, and you're like, yay me, I got it right.
well, I've started taking Colby's trick in Googling pronunciations if I have time before, so I don't have to, because I have a hard time hearing them
Oh, that's a
pronounce it
great
and then
idea.
remembering it. So sometimes in the interrupt, I'm Googling the pronunciation and listening to it over and over again.
Yeah. So you
I
have
started
a-
doing that because I was tired of Dean making fun of me and my French name mispronunciations.
It was just the French names.
I can do French most of the
Yeah.
time. It's some of the others. Whew.
What are the
Spanish.
categories in here? What are the domains?
Ability
in
to
this one?
control behavior. I have Lynn and Pat at aggravating and Wayne at mitigating.
Obviously, the other two are wrong.
It's just
He had substance abuse issues along with anger and mental health issues. So that's why I put aggravating.
Yeah, I probably would have gone with aggravating.
Looks
If
like
I was
Wayne was
scoring it.
looking at his programming issues.
it's a her, by the way, everybody.
It's
a her.
Sarah.
Sarah, is it her? Okay.
Yeah.
Sarah,
Well, I put as a has completed risk reduction, but DOC is worried about the violence of her crimes. So that one to me is aggravating.
Why was it mitigating, Wayne?
I'm trying to see where I put mitigating.
Because it's the history, so.
On what?
Ability to control behavior.
Control the second one. Ability control behavior.
I
So
have
you know,
aggravating. No, I don't.
No.
I'm sorry. Whoop.
You're on the bottom.
Yeah, I'm working on it. Ah, there I am.
Looks like he was using the programming criteria and
Yeah.
put it into the behavior one.
Yeah. He's
You put
done
mitigating
a
on
whole
a
bunch
lot
of good stuff while he's
Right.
been incarcerated, as
Which
well
you-
as no DRs.
Oh,
Since
wait, it's
22.
Yeah, but it's previous, it's history of behavior.
That's not
Not-
controlling behavior, that's
At-
programming.
it's the behavior at the time of the offense.
It's definitely not mitigating.
Okay, neutral.
She's got victims. Ag assault with a deadly weapon, that is not mitigating, my friend. Two of them. Ag domestic with a weapon,
It'd be mitigating to have it aggravating.
And then the next one is programming. Lynn's a neutral, Pat's an aggravating, and Wayne's a mitigating. Just looking on the surface, I really want to know how you got aggravating, Pat.
Which
Isn't
one,
she the
which
one-
category?
she took a
Programming.
bunch of classes.
Programming, yeah.
Let me see. I guess I based it on the fact that they haven't completed programming based on risk, needs, or responsivity.
But was she required to do any in the facility?
That I can't remember. Evidently not, because it said, I guess I based mine on the fact that they were gonna do it once they were in the community, so they haven't done it while they've been incarcerated, so that's why I put aggravating.
Yeah, but that's not quite right, Pat, because both Wayne and I has done everything in the facility that she was required to do. So she did do stuff in the facility.
By the sounds of what you wrote, a lot of stuff.
And Wayne wrote, has taken great advantage of DOC and 7-week course in restorative justice, helping women recover, 16-hour legal ed course, like.
So,
Where'd I
so
write
to
that?
look at this, I would think at a minimum you'd go neutral because the offender has completed some correctional programs, but one or more elements of risk needs or responsivity were not adequately addressed, or no specific programming was warranted. So you're looking at programming at the time. We can't predict this is not a future programming domain.
Right. I can go with neutral.
Mhm. I also have, she's currently
I
doing
understand that.
CCD.
Yeah, I would say she's definitely not aggravating.
Yeah.
Good.
I'm good. I'm good with that.
Yep. Yeah. Are there any other domains in this one?
No, not in this one.
Great.
I didn't pick out other cases. There were other cases.
Yeah.
I just picked out 3 for the essence of time.
Yeah.
Yep.
No, I'm glad you did.
But I think this is, I mean,
It's been a
overall,
while
looking
since
at
we've
this,
looked at them.
and looking at this, it's not bad at all. I think we're pretty consistent in everything.
But it is helpful to review them like this occasionally.
Yeah,
It is.
it does, for sure.
I need to step away for 1 quick minute. I apologize.
Anyways,
We can go over the schedule.
yeah, I think I've got everybody. I'll put that out this afternoon. Thank you for getting back to me.
Thank you, back.
If you don't hear from me right away with it, Dean, send me it to my other email
I will. Yeah.
when you have a request,
Yeah.
because
I just
I
sent
check
it out.
that every day. It's
Yeah. Okay.
the state one that I'm not on very often.
Yeah. No problem. I'll find you.
And Dean, just that information that I gave you about March, that's just to give you a heads up.
Yeah. Thank you.
Yeah.
Yeah. Yeah. Absolutely. Okay. I don't
Yeah,
think
I'm
I've got
trying to get
anything
my-
else.
Trying to get my Norwegian citizenship back. I can't handle this president.
Oh, I
You're-
get it.
You're in good company.
Gulf of America. Jesus Christ.
I know. That's ridiculous.
He's trying to be
Pure
God.
entertainment.
Anything else from anybody? Good. Okay.
I had the $1 million question, but now she's not here. Maybe Colby or Carla can answer it. Have we yet to see a violation of parole for a presumptive parole case?
I believe we have.
Yeah.
I
Okay.
can't tell you right off the bat who it was, but
No,
I
it doesn't
believe
matter. I just
we've,
wondered.
I can recall seeing at least one.
Really?
Okay.
Do we have a
Interesting.
number of how many people are on presumptive parole? Is it less than like 10?
That I'm not sure of. MJ probably has that, but it's
Yeah.
probably right around that mark.
Yeah.
Sure.
I know we haven't seen a lot of them.
No. I'm sure it's less than 10.
Yeah, I was just curious.
The big increase has been obviously the violations and the time that those take.
Yeah, I was thinking about asking. I forgot to ask Lori if there was any way to put a muzzle on those PRO people and say, well, you can only share for 3 minutes. That's all. and get a handle on Don Sievert. Jesus.
I know. Good luck with that.
And she was gone for a very long time and now she's back.
Yeah, I'd really like to that long time to happen again. Ugh.
We'll get our expense reports to you.
Yes, yeah.
Oh, yeah. Might as well send that out. Right.
I had a lot of problems with the new expense report you sent.
You did?
Yeah,
Yeah.
it doesn't
Yes.
add the numbers up.
It said,
Oh, really?
it
I'll
said
take another
it
look
was
at it.
read only and I couldn't type anything in.
Oh, no kidding.
I had a rough time. I'm hoping I got it right now.
Okay.
But yeah,
It shouldn't be a read only, but I'll double check that.
Yeah, it said read only and I tried to trick it and do other things. It didn't work.
Okay.
But hopefully I got it.
Okay. Well, I'll send it out again.
Okay.
And Dean, if you need me to take
I was able to work it.
And Dean, if you
Okay.
need me to take a look at it, I'd be more than happy to
Okay.
look at it too.
Thank you. Yeah.
Because I see some stuff offhand, just looking at it, some formulas don't look to be correct. If you want me
Yeah.
to I can go in quickly if you want and just
Yeah. Okay. The only change I made was the
mileage.
the mileage
mileage.
reimbursement rate went from 67 to 70. But-
All
Yeah.
you guys who are lucky
better
to get
go
the full
driving again.
reimbursement. Yeah, I'll take a look at it, everybody, and I'll send it back out.
Okay.
Thank you.
Thanks.
I just
MJ.
I just sent you mine.
Okay.
Sorry, I had a district manager calling
Yep.
me on a parole violation case. A guy got sentenced to a new minimum that's in September, and they're like, "What do we do?" So
Oh.
I'm like, "We got to have his hearing." So
Yeah.
maybe
Let's do it.
I go talk to your attorney. Get some wheels turning in the background.
Okay. Anything else, MJ?
Did you guys talk about the schedule while I was gone?
Yeah, I had
Perfect.
asked everybody to give me their dates and I've got everything together, so I'll put that out this afternoon.
Okay.
Great. Anyone
I'll
else
make a
have
motion
anything?
that we adjourn.
Okay.
A second.
Motion's made and seconded to adjourn the meeting. All in favor signify by saying aye.
Bye.
Okay, thanks, everybody.
Thanks, everybody.
Thanks,
Bye.
guys.
Bye, everyone.
Thanks for all your hard work.
See y'all.